is a Yale law degree and Supreme Court pedigree, enough to beat the cold precision of a lawyer from Houston. The Senate Judiciary Committee hearing room held its breath. Overhead lights pooled on a row of silver mics as Senator Josh Hawley leaned in, a confident smile at the corners of his mouth. For 20 minutes, Representative Jasmine Crockett had gone point by point, statute, precedent, citation, dissecting his proposed constitutional amendment like a surgeon. Representative Crockett, Hawley began, voice filling the room. A Yale law degree and a Supreme Court clerkship give me a foundation, perhaps stronger than someone from the University of Houston Law Center. In Texas, maybe they teach constitutional interpretation differently than the institutions that shaped American legal thought. A beat. Then murmurs rolled across the gallery. Crockett locked eyes with him, tapped the mic, click, and answered, even and precise. Senator Hawley, while you were publishing articles at Yale, I was winning at the Fifth Circuit on the very provisions we're debating. While you clerked for one justice, I was building precedent across 3 circuits. And when your amendment cites Harrington v. California, it misreads Justice Douglas's opinion, which I know because I interviewed his last living clerk while preparing Jenkins v. Texas, a case I won 8-1 at the Supreme Court last year. The smile vanished. Pens froze mid-stroke, then raced ahead. The room's tempo shifted, from pedigree imposing authority to arguments forced to stand on their own. Not a routine spar, but a reset. Credentials versus courtroom-tested expertise. Want more showdowns where calm, grounded argument compels power to yield hit subscribe and join the Jasmine Crockett file community. We bring you political moments that don't just shock. They inspire informed action. While you were writing academic articles at Yale, I was successfully arguing before the Fifth Circuit on the very constitutional provisions we're discussing today. When you clerked for one justice, I was litigating cases that established precedent across 3 circuits. And when your amendment cites Harrington v. California, it fundamentally misinterprets Justice Douglas's opinion, which I know because I personally interviewed Justice Douglas's last living clerk while preparing for Jenkins v. Texas, which I won 8-1 before the Supreme Court last year. So yes, perhaps we do teach constitutional law differently in Texas, with an emphasis on practical application rather than theoretical credentials. The room fell silent. Hawley's confident smile vanished as committee members straightened in their seats, suddenly alert to the significance of what they were witnessing. Before diving into this extraordinary confrontation between 2 of America's most qualified legal minds, comment where you're watching from, and don't forget to subscribe so you won't miss our latest political analysis. Representative Jasmine Crockett had built her reputation in Congress through substantive legal expertise rather than political grandstanding. A graduate of the University of Houston Law Center, where she had served as editor of the Law Review. Crockett had practiced constitutional law for 15 years before entering politics. Her legal career wasn't merely academic. She had successfully argued major cases before multiple federal circuits, establishing significant precedents in voting rights, due process, and equal protection jurisprudence. Before joining Congress, Crockett had been named to the prestigious American Law Institute and had co-authored 3 amicus briefs for Supreme Court cases, 2 of which were specifically cited in majority opinions. Her scholarly articles on constitutional interpretation had appeared in the Harvard Law Review and Stanford Law Review, despite her not being affiliated with either institution. The Constitution isn't an abstract document, she had explained during her first campaign. It's a living framework that directly impacts Americans' daily lives. My approach to constitutional law has always focused on practical application to how these principles protect real people facing real challenges. At 42, Crockett maintained the precise attention to detail and rigorous analysis that had characterized her legal career, approaching congressional hearings with exhaustive preparation and a command of both constitutional theory and practical implementation. While some colleagues relied on staff briefings, Crockett was known to spend evenings personally researching the historical context and precedential foundations of pending legislation. Senator Josh Hawley had forged a different path to legal prominence. A graduate of Stanford University and Yale Law School, Hawley had clerked for Chief Justice John Roberts before entering academia as a professor at the University of Missouri School of Law. His scholarly work on constitutional originalism had earned recognition in conservative legal circles, and he had leveraged this expertise first as Missouri Attorney General and then as a U.S. Senator. Hawley's proposed constitutional amendment, the subject of the current hearing, would establish new limitations on federal authority over state election procedures, titled the Electoral Federalism Amendment. The proposal sought to codify a stricter interpretation of states' rights in election administration while limiting federal oversight. This amendment would restore the founders' vision of electoral federalism. Hawley had explained when introducing the proposal, it reaffirms that states, not Washington bureaucrats, should determine how their citizens elect representatives. The specific hearing that brought Crockett and Hawley into direct conflict was a joint session of the Senate Judiciary Committee and House Judiciary Committee, an unusual format reserved for constitutional amendments with significant bipartisan interest. The amendment had gained support from states' rights advocates while raising concerns from voting rights organizations and constitutional scholars about potential impacts on equal protection guarantees. As the hearing began, few anticipated the dramatic confrontation that would unfold. Both Crockett and Hawley were known as serious legal thinkers who generally focused on substantive arguments rather than personal attacks. But beneath their professional demeanors lay fundamentally different approaches to constitutional interpretation, differences that would soon erupt into one of the most memorable exchanges in recent congressional history. Chairman Durbin called the Joint Committee hearing to order at 10:00 sharp. Today we examine Sessa J. Res. 42, proposing an amendment to the Constitution regarding election procedures. Senator Hawley, as the primary sponsor, you have 15 minutes to present your proposal. Hawley approached the podium with the confident bearing of a former Supreme Court clerk. For 15 minutes, he outlined his amendment with references to the Federalist Papers, early constitutional debates, and founding-era understandings of federalism. His presentation was articulate and scholarly, designed to appeal to originalist interpretations of constitutional structure. The founders clearly intended states to determine their own election procedures, he explained. This amendment simply restores that original understanding while preserving fundamental rights. Section 1 establishes that states have primary authority over election methods. Section 2 prohibits federal regulations, except where necessary to protect constitutional rights. And Section 3 requires a heightened judicial standard of review for federal interventions. Hawley cited historical precedents supporting state autonomy in election administration. From the ratification debates through early constitutional practice, the evidence consistently shows that the founders viewed electoral procedures as fundamentally state matters. This amendment doesn't change the Constitution. It restores the Constitution's original meaning. When his time concluded, Chairman Durbin opened questioning. Representative Crockett, you are recognized for questions. Crockett approached her microphone with the measured confidence of an experienced constitutional litigator. Thank you, Mr. Chairman. She looked directly at Hawley. Senator, I appreciate your historical references to the founders' intent. However, I'm concerned that your analysis overlooks significant constitutional development since the founding era, particularly the Reconstruction Amendments. She opened a well-worn copy of the Constitution. Article 1 to Boerne. Section 4 states that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations. This explicit reservation of congressional authority seems directly contradicted by your amendment's limitations on federal oversight. How do you reconcile this textual inconsistency? Hawley appeared momentarily surprised by the direct textual challenge, but recovered quickly. Representative Crockett, the original understanding of that provision was far narrower than modern interpretations suggest. Contemporary records indicate the founders intended congressional authority as a fail-safe against state inaction, not as general regulatory power. That's an interesting interpretation, Crockett replied. But it seems inconsistent with both the plain text and early implementation. In 1842, Congress enacted the first federal requirement that House members be elected from districts, overriding states that elected representatives at large. The Supreme Court upheld this federal action in ex parte Siebold, establishing that when Congress acts under Article 1, Section 4, its authority is paramount to the states. She continued methodically. More fundamentally, your historical analysis appears to stop in 1789, overlooking constitutional transformations wrought by the Civil War amendments. The 15th Amendment explicitly grants Congress enforcement power regarding racial discrimination in voting. The 14th Amendment's Equal Protection Clause has been consistently interpreted to authorize federal intervention when state election procedures discriminate, as affirmed in Harper v. Virginia Board of Elections, and subsequent cases. This historically nuanced critique, delivered without notes, revealed Crockett's deep constitutional expertise. Hawley shifted approach, moving from historical arguments to textual analysis of his amendment. My amendment preserves these constitutional protections, he countered. Section 2 explicitly allows federal action where necessary to protect constitutional rights. This simply establishes a proper balance between state authority and federal oversight. I appreciate that clarification, Crockett responded. But the language in Section 3 seems to undermine that balance. It requires courts to apply strict scrutiny to federal election regulations, a standard typically reserved for potential constitutional violations. This effectively treats congressional exercise of its explicit Article 1 authority as presumptively unconstitutional. Inverting the constitutional hierarchy established by the Supremacy Clause, she displayed the amendment text on screen, highlighting specific language. Furthermore, Section 3(b) states that courts shall not defer to congressional findings of fact when reviewing federal election regulations. This directly contradicts established separation of powers, principles dating back to McCulloch v. Maryland, where Chief Justice Marshall established that Congress has latitude to determine necessary and proper means for exercising its constitutional powers. This precise legal analysis, identifying specific constitutional contradictions rather than general concerns, seemed to catch Hawley off guard. He responded with increasing defensiveness, shifting from constitutional substance to procedural objections. Representative Crockett, with all due respect, you're misinterpreting both my amendment and the constitutional principles it embodies. The amendment preserves congressional authority while preventing overreach. I'm struggling to reconcile that assertion with the amendment's actual text. Crockett replied. Section 1 states that the power to determine the manner of holding elections is reserved to the states. This absolute language directly contradicts Article 1, Section 4's explicit grant of congressional authority to make or alter state election regulations. She continued without referencing notes. This contradiction creates a fundamental constitutional problem. Under Article 5, amendments can change constitutional provisions, but cannot create irreconcilable internal contradictions. The Supreme Court established this principle in Sprague v. United States, noting that amendments must be integrated into the constitutional whole rather than creating isolated provisions that contradict foundational structures. This invocation of a relatively obscure constitutional doctrine, delivered with the precision of a law professor, visibly frustrated Hawley. Rather than engaging with the substantive legal critique, he attempted to dismiss it by questioning Crockett's credentials. "Representative Crockett," Hawley said, his voice carrying throughout the chamber, "I appreciate your enthusiasm, but I think there's some confusion here. My Yale law degree and Supreme Court clerkship suggests I might understand constitutional jurisprudence a bit better than someone from the University of Houston Law Center. Perhaps in Texas, they teach constitutional interpretation differently than at the institutions that have shaped American legal thought for centuries." The personal attack, unusual in a committee focused on constitutional substance, created a palpable tension in the room. Several committee members appeared startled by the shift from legal debate to credential comparison. Representative Crockett sat motionless for 3 seconds, her expression unreadable as she studied the senator. When she finally spoke, her voice remained measured, but carried unmistakable authority. "Senator Hawley," she began, "while you were writing academic articles at Yale, I was successfully arguing before the Fifth Circuit on the very constitutional provisions we're discussing today. When you clerked for one justice, I was litigating cases that established precedent across 3 circuits. And when your amendment cites Harrington v. California, it fundamentally misinterprets Justice Douglas's opinion, which I know because I personally interviewed Justice Douglas's last living clerk while preparing for Jenkins v. Texas, which I won 8-1 before the Supreme Court last year. So, yes, perhaps we do teach constitutional law differently in Texas, with an emphasis on practical application rather than theoretical credentials." The response, precise, factual, and devastating in its substance, created absolute silence in the hearing room. Several committee members visibly reacted, some exchanging glances of surprise, others quickly reviewing their notes as if suddenly reassessing the dynamics of the hearing. Chairman Durbin, recognizing the significance of the exchange, intervened smoothly. "I appreciate both members' perspectives on these important constitutional questions. Let's continue with questions from other committee members." But the dynamic of the hearing had fundamentally changed. What began as a routine committee session had transformed into a defining moment that legal observers would later describe as the day credentials collided with actual constitutional expertise as questioning continued. The shockwaves from the Crockett-Hawley exchange moved through the room like a pressure change, subtle at first, then unmistakable. Members who had defaulted to Senator Hawley for answers began redirecting their questions down the dais, looking to Representative Jasmine Crockett for how, exactly, this amendment would live in the real world of litigation and enforcement. The pivot became explicit when Senator Amy Klobuchar, a former prosecutor, entered with a question squarely in Crockett's strike zone. "Representative Crockett, given your experience litigating constitutional cases, could you elaborate on how the proposed amendment might affect existing voting rights jurisprudence? I'm particularly interested in potential impacts on Section 2 of the Voting Rights Act. It was the kind of inquiry that leaves little room for rhetoric and rewards command of doctrine." Crockett didn't glance at notes. She framed the terrain and walked the committee through it. "Thank you, Senator." The amendment creates several significant tensions with established voting rights jurisprudence. She pointed to the wording that would require courts to apply strict scrutiny to federal election regulations, an analytical inversion that, she explained, would fundamentally rework the framework established in Thornburg, Fatwa, Gingles, and refined in subsequent cases. Today, Section 2 claims are evaluated under a totality of circumstances test to capture discriminatory effects, she said. By imposing strict scrutiny on federal regulation itself, the amendment would reverse the burden, forcing the government to prove a compelling interest and narrow tailoring for each application of Section 2. A staff display flared to life. On one side, a clean flowchart of current VRA litigation. On the other, the altered path under the proposed amendment. Crockett mapped it to a concrete example. North Carolina State Conference of the NAACP, McCrory, where the Fourth Circuit found discriminatory intent in voter ID provisions. Under this amendment, she observed, the court's scrutiny would shift toward the Voting Rights Act rather than the state's potentially discriminatory action. Heads lifted. Pens resumed. The committee wasn't merely impressed with the polish. They were tracking the stakes. Senator John Cornyn, himself steeped in judicial practice, pushed toward a deeper fault line. Representative Crockett, from your litigation experience, how might courts reconcile Section 3's judicial review provisions with existing standards for reviewing congressional action under Section 5 of the 14th Amendment? Crockett didn't hesitate. That's an insightful question. Senator, the amendment creates a direct doctrinal conflict with established Section 5 jurisprudence in City of Boerne v. Flores. The court recognized Congress's broad enforcement authority to address discrimination, requiring only that legislation be congruent and proportional to the constitutional violation. On the display, excerpts from Boerne appeared alongside the amendment's text, replacing the congruent and proportional standard with strict scrutiny for election regulations, she said, would effectively nullify Congress's Section 5 enforcement power in this context. You then have an irreconcilable tension between a constitutional grant of power and a new provision that constrains the exercise of that power. The point landed without theatrics, just the quiet gravity of doctrine colliding with doctrine. And it marked another shift. While earlier Hawley had met Crockett's critiques with visible impatience, he now listened with the deliberate stillness of an advocate recalibrating in real time. When he spoke again, his tone had moved from adversarial to exploratory. Representative Crockett, Hawley said, voice level. You've raised important questions about potential conflicts with Reconstruction Amendment jurisprudence. How might the amendment be modified to address these concerns while still preserving the principle of state primacy in election administration? For seasoned observers, it read as a concession without surrender, the senatorial equivalent of an extended hand across the witness table. Crockett accepted the opening on the terms she'd defined from the start. Substance over status. That's a constructive question. Senator Hawley, the fundamental tension could be addressed by revising Section 3 to acknowledge the distinct constitutional status of legislation enacted under the 14th and 15th Amendments. She offered drafting language, not slogans. For example, a clause stating that nothing in this amendment shall be construed to limit congressional enforcement power under the 14th and 15th Amendments would preserve general state authority over election administration while safeguarding federal capacity to protect constitutional rights. She wasn't finished. Additionally, replacing strict scrutiny with a substantial relations standard would better align with federalism jurisprudence while still providing meaningful review, consistent with the court's reasoning in Shelby County v. Holder, which recognized both state sovereignty interests and the federal mandate to prevent discrimination. The point, as she made plain, wasn't to obliterate state primacy. It was to harmonize it with the Reconstruction Amendments protection mission. The tenor of the room altered again. This wasn't the blood sport of politics in miniature. It was drafting, doctrinal cleanup, reconciliation of text with text. What hearings are supposed to be when they rise above the performance of partisanship. Chairman Dick Durbin sensed it, and he gave the moment room to breathe. "I believe the committee is benefiting from this detailed constitutional analysis," he said, extending the questioning. Senator Richard Blumenthal, a former state attorney general, took the invitation to the ground level where courts actually work. Representative Crockett, having litigated constitutional cases, "Could you address how this amendment might affect pending election litigation in federal courts?" Crockett went directly to Section 4. "There's language that could be read to apply retroactively to pending cases," she said. "That raises serious separation of powers concerns under Plout Ver, Spendthrift Farm, which holds that Congress cannot retroactively compel federal courts to reopen final judgments. While the amendment doesn't explicitly order reopening, directing courts to apply this amendment to all pending cases creates tension with Article 3's vesting of judicial power." Again, the contrast with Hawley's earlier historical emphasis was unmistakable. Crockett anchored her answers in docket realities, standards of review, the flow of cases, the machinery of enforcement and appeal. In that register, members across the aisle didn't just hear her, they recognized the practical value of the vantage point she brought. Hawley spoke once more, this time narrowing his claim while validating hers. "I appreciate Representative Crockett's technical analysis," he said. "While I maintain the amendment's core purpose is constitutionally sound, her suggestions regarding potential conflicts with Reconstruction Amendment jurisprudence merit serious consideration. Perhaps we can work together to refine the language while preserving the principle of state primacy." Durbin seized the momentum. "Would the two of you be willing to work together on amendment language addressing these constitutional tensions before our next hearing?" He received 2 yeses, unadorned and consequential. By adjournment, the arc of the day was plain. The hearing opened with a reference to Yale and a tacit appeal to Pedigree. It closed with 2 lawmakers agreeing to reconcile an amendment's architecture with the Constitution it aimed to inhabit. In her closing, Crockett kept the tone she'd set all along. "Constitutional amendments require the most careful consideration," she said. "Not because change is impossible, but because new provisions must harmonize with existing structures. I look forward to working with Senator Hawley to address these doctrinal tensions while respecting the legitimate federalism concerns his amendment seeks to address." The room exhaled. Members gathered folders and tablets. A few crossed the aisle to ask Crockett follow-ups on particular clauses, a small gesture, but in this town, a telling one. For reporters, the storyline shifted from a skirmish over credentials to a case study in how practical expertise can reset a debate. One veteran Supreme Court correspondent put it cleanly to a colleague on the way out. That wasn't a quip. That was a clinic. The public read it the same way. By evening, the exchange ricocheted across cable segments and social feeds, not for its sting alone, but because it showcased a substantive divide, authority asserted by resume versus authority earned in the well of a courtroom. The New York Times' legal affairs desk distilled it with a headline that traveled beyond credentials. The Crockett-Hawley exchange as constitutional moment. The analysis emphasized something increasingly rare, a debate where specific doctrine and litigation experience outweighed institutional pedigree. Academics weighed in from both directions. Conservative commentator Orrin Kerr called Hawley's foray into credential checking a tactical misstep in an area where Crockett clearly possessed superior practical expertise, adding that the lesson was methodological, not ideological. Lawrence Tribe highlighted Crockett's most durable strength, not merely that she'd litigated, but that she translated experience into solutions, identifying doctrinal collisions and proposing precise fixes. Hawley, for his part, navigated the aftermath with a notable adjustment. An initial tweet framed the day as rigorous constitutional debate, a gesture toward normalcy that didn't survive the full-clip context. 3 days later, on Fox News, he acknowledged what viewers had already intuited. Representative Crockett raised legitimate constitutional questions about potential tensions with Reconstruction Amendment jurisprudence. We approach interpretation differently, but I respect her experience. That's why we're working together to refine the language. The move drew praise for intellectual honesty and, more importantly, cleared runway for the work to continue. Within 2 weeks, a significantly revised draft emerged from the Senate Judiciary Committee, officially credited to Hawley Crockett. It retained state primacy in general election administration, while adding explicit language preserving congressional authority under the 14th and 15th Amendments. Section 3's strict scrutiny trigger gave way to a more calibrated, heightened scrutiny standard, aligned with federalism precedent. Section 4's retroactivity language was tightened to avoid plot concerns. At a joint press availability, Hawley emphasized state sovereignty. Crockett underscored civil rights enforcement. The choreography wasn't cosmetic. It reflected a real harmonizing of aims. The process itself drew scholarly attention. Harvard Law Review ran constitutional dialogue in practice. The Hawley Crockett amendment process, arguing that the revision showed how critique grounded in litigation can refine constitutional text to fit the structure it must inhabit. Editorial boards used the episode to reopen a broader conversation. Do we overweight pedigree at the expense of proven courtroom judgment? What voices do we elevate when doctrine meets life? The ripple effects reached the classroom. Several top law schools expanded constitutional litigation offerings, citing the exchange as a reminder that interpretation is not only theory, but craft. In interviews, Crockett declined the victory lap, redirecting to first principles. What matters is how constitutional guarantees are made real for the people who need them. And that may be the clearest legacy of the day. The confrontation didn't end in humiliation or triumphalism. It ended in better text. It demonstrated, in public, how constitutional dialogue can function when the participants accept the burden of coherence, when amendments are measured not just by aspiration, but by how they integrate with the document they seek to amend. Share your take below. I genuinely want to hear what resonates with this audience. If this kind of grounded, high-stakes analysis works for you, please like, share, subscribe, and hit the notification bell to catch more stories like this. And before you go, check out the featured video on your screen. It's a piece I'm especially proud of. Thanks for your support, and I'll see you next time. Jasmine Crockett File.